Hello and welcome to another episode of Good to Know Family Law Topics. In this segment, I'm going to talk about who gets the family residence at the conclusion of a divorce proceedings. The decision as to who gets the family residence is not an easy one, given the significance our houses play in our lives. Owning a home in America is part of the American dream, and our houses are where we try to create stability for our families, especially when we have children. The first thing that you should know is that the court has wide discretion as to how to dispose with the family residence. There is not a clear-cut answer going into a divorce as to what's going to happen to that home. The court can, in its discretion, sell the home and make the parties split the proceeds. In the alternative, the court could award the house to one of the parties where the court believes that it makes the most sense to do so. The second thing that you should know is that the parties can always stipulate as to which party is awarded the family residence. This requires a buyout, where one party buys out the other party's interest in the family residence. And of course, this always requires an appraisal as to what the fair market value of the home is. Usually requires hiring an expert. And the third thing that you should know is that where the parties cannot agree as to the fair market value of the property, then this issue is litigated in court, and there's typically a battle of the experts where both sides have experts that go into court and they render their opinions as to what the fair market value is, and the court has to decide what the actual value is. Now let me give you a couple of tips as to whether or not you should try to keep the family residence at the conclusion of the divorce. The first thing that you should consider is that you shouldn't make an emotional decision on this issue. A lot of people want to keep the family residence, but they cannot afford to do so. Before you decide to litigate over this issue, first determine whether or not it makes financial sense. You may want to speak to a financial planner in making your decision. The second thing that you should consider is that the court will authorize the parties to have a delayed sale of the family residence. The parties could simply agree that the residence will be sold at a later date. Typically, we see this when there are children and both parties want the children to remain in the family residence for their childhood. These type of orders typically result in an agreement where the parties say, well, the home will sell when the children are 18 and have graduated high school. Now, to do this, the judgment has to be very clear as to when the home is going to be sold, what the listing price will be, who will choose the broker, and other important details. And that concludes our topic for today. Thank you again for joining us on Good to Know Family Law Topics, and be sure to follow us on Facebook and on our website to learn more about very important family law topics.